Mr. Meekoff, you have the right to make a statement if you so choose.
I guess all I've got to say is that night was 35-mile-an-hour winds. It was windy. I hadn't drank until I was at the parking lot waiting for my ride to pick me up.
All right. Our next case is People of the State of Michigan versus Joshua Meekoff. Did he just walk out? He did. Hartel. All right, so this is case number 26-3659FH. Is this Mr. Meekoff?
It is.
Yeah, sit next to him. All right, thank you. He doesn't bite.
This guy's about to get sentenced for his third drunk driving charge, but wait till you hear how drunk he actually was, and that there was a loaded gun sitting right next to him in the car.
Yeah, hard. All right, appearances. Mr. Denham, did I get yours already?
Not yet, you're right. Thank you, David, and on behalf of the people, Your Honor.
Thank you.
Robert Hartzell for Mr. Meekoff, who joined me to the left, Your Honor.
Right, you may be seated. All right, we're here today for sentencing in this case. It involves conviction for 2 and operating while intoxicated is a third offense, and possession of a firearm while under the influence. It was resolved with a couple pleas of no contest back on May 8th. One moment. Yeah, there we go. I knew I had something else. So review these earlier. All right, so also before we get to the pre-sentence investigation report, this court received last, I think it was Wednesday or Tuesday, a Catholic Human Services report on Mr. Meekoff talking about or giving me an alcohol or substance use assessment. I read through that, made some notes and things like that. So I covered that last week, and also received by my office on that same day was a mitigation report for Mr. Meekoff. And normally I make notes, so give me just a moment. Oh yeah, the Sarah Lee Baker. All right, now I remember. And then attached to that were several letters. We have one from Dr. Deere, who is at the Lakeshore Community Counseling Center, talking about the progress there. And there were some other statements or letters here that I received. Okay. And it looks like he's done a pretty consistent job here with attending AA classes. All right. Let's turn right back here to the pre-sentence investigation report. Mr. Denham, do people have any amendments, corrections, objections to make to the contents of that report?
Thank you, Your Honor. I have reviewed that report thoroughly, and I have no proposed corrections, additions, or deletions.
Okay, thank you. Mr. Hartel, same question, sir.
Yes, Your Honor. We asked the court to consider on CFJ 145 under the term of the probation, term 4.20, amending that just to no firearms. I do believe it would be appropriate. That way my client could still go bow hunting, things of that nature. We're not sure how much probation the court's going to give him, but I don't believe there are any allegations in the report of any bows being misplaced, anything. I do realize there were other issues the court may take issue with.
Which you said 4.20?
I believe that's the condition where it mentions no weapons, Your Honor.
Yeah. All right.
I know the court sometimes has given that grace. I'd ask the court to consider it in this situation. Thank you.
Thank you. That's really more for allocution and mitigation. Mr. Denham, do you have any comment on that?
On that particular condition, I would simply leave it to discretion.
Copy that. Thank you. All right. Let me take a quick look. Anything else, Mr. Hartel, as to the contents of the report?
No, Your Honor.
All right. Thank you. I'll just note here, I did go through, obviously, the CFJ 384 section. There were a couple of charges or cases for which he had some dismissals. Clearly, the court does not take those into consideration. And I don't think I had any other corrections here to make. All right, allocution. I'll start with Mr. Denham.
Sure. Thank you, Your Honor. First, the people, I guess I'll start out positive. I'm not aware of bond violations, any bond violations. So I'll give credit to the defendant for that. I think that he's been performing well on bond. However, the defendant did receive a significant benefit of the plea agreement. We did dismiss the felony firearm count. I support the recommendation. The incident itself involved allegations, being on the lookout call. Allegedly, the defendant was all over the roadway. Ultimately, he was found as a local Wesco. He was somewhat non-compliant. When the blood draw was done, which was approximately 2 hours after the incident, so a significant period of time had elapsed, he still had a blood alcohol content of 0.239, which is, as the court is aware, about 3 times over the legal limit. So significant.
Steve, I think we need to learn from the challenge.
Hold on just a minute. Go ahead, Mr. Young.
Okay, so significantly over the legal limit. There was a loaded gun in the vehicle. There were vodka bottles, at least 2.
A 0.239 blood alcohol level, almost 3 times the legal limit, 2 hours after he was already pulled over. That means it was even higher at the time he was actually driving, and there was a loaded gun in the car the whole time. This is exactly why the judge is about to lose his patience.
The PSI report notes that there's been a series of drinking and driving convictions in a relatively short span in the last few years. The defendant, I guess, reached my radar and of some concern on the 2024 incident, the failure to report an accident. That involved the defendant running into the backside of a manure spreader that was going 33 miles per hour at the time. He went into the ditch, went through the windshield. Witnesses indicated that blood was coming from his nose, and he was picked up from someone. So that raised some concerns for the people, given that scenario. He was not at the scene, so he was not charged. I'll leave it at the leaving the scene of an accident. But certainly that raised some additional concerns separate and apart from the OWI convictions. I do support the recommendation, Your Honor. I would respectfully request the court follow the recommendation of the probation department.
Mr. Hartel, did we miss something? Did there need to be a change?
Not that needs to be changed, Your Honor. My client may or may not wish to make a statement after my elocution. That's what he was informed.
Oh, okay, no problem. All right, thank you. Mr. Hartel, floor is yours.
Thank you, Your Honor. We also recognize that my client received a significant benefit from this plea. We realized there was an absolute minimum sentence as it was charged that would have sent him to prison. We're very glad that's not happening. He's cognizant of that fact here today. He is employed, as the court did note, at Sara Lee Factory. He reminded me earlier this morning, his shift is from 2 a.m. to 2 p.m. Quite the fun shift. I've done a few of those myself at different locations where things close to them, maybe graveyard shifts is my point. We would ask the court to fashion a sentence where he could maintain that employment and do the jail sentence on the weekends. We realize there's a minimum 30 days here, and the court can go about that. But I know sometimes the court does allow, with its grace, to allow my clients to do 48-hour chunks on the weekends. And even though I've informed him you most likely would want a GPS tether on him as you've done in the past, he would be willing to comply with that. He very much so wants to keep this job. He's informed me he has the support of his coworkers. He wants to continue to show them that he can be a good colleague, have his job so that he has good support structure when he gets done with the term of probation that we don't doubt, Your Honor, will give him probation as well. He also continues to have the support of his family. I know some friends and family wrote letters. Others, I'm informed, still support him, but just didn't quite get the pen to the paper, but are definitely still there. They may or may not be watching right now, in fact. I would also ask the court to consider allowing him a week before starting any jail sentence so that he could tell his employer exactly what's going on. He was honest with them, he tells me, but because he didn't know exactly what the sentence would be, he obviously wasn't able to communicate that. So if the court give him a little bit of grace before the first day in jail, we'd appreciate that as well. As was noted a moment ago, he may or may not wish to make a statement. That's at his discretion. I've given him my advice on which things may or may not be the best to say. I realize this was a no contest, so I won't overly allocute. I know the court has to take everything in the report as accurate, but because it was more for lack of recollection than civil liability, if he suddenly had better recollection, I just ask the court to factor that in. Thank you.
All right. Mr. Minkoff, you have the right to make a statement if you so choose.
I guess all I've got to say is that night was 35-mile-an-hour winds. It was windy. I hadn't drank until I was at the parking lot waiting for my ride to pick me up. Vehicle was off. And the person picking me up did speak to the cop on the phone when he approached me, I was on the phone with them. I guess that's about it. Again, if I could somehow maintain my job, that'd be great. Or if not, I understand.
So, okay, I'm sorry, keep going.
I guess a week or so I could get my house arranged. That way I could let my landlord know that I'd be leaving the property or whatever.
Whose vehicle was this?
Well, it was my mother's.
How'd you get it?
I was working on it.
Okay. How do you get to and from work?
I get picked up. I carpool. That my mom will take me to work.
How is that you remember this now and you didn't remember anything last time I took the plea 2 months ago?
I guess I didn't really quite understand everything.
What do you mean you didn't understand everything?
As in like the no contest or
I
whatnot.
explained it to you. I told you you couldn't challenge what was in the report.
Right.
But how
Yes,
was that? No, how was that not clear?
I guess I just wasn't. I mean,
You weren't being honest with yourself or with the court, because I'm pretty clear when I do a no contest plea.
right.
And you told me you couldn't remember. Which means if you try to tell me you remember stuff, I think you're lying. So I don't know. There is no better way to explain it than I do. I'm pretty sure. I'm not patting myself on the back, but I say you cannot challenge what is said in here. And so I don't care if it was windy. You were obliteratedly drunk, swerving, putting people in danger. Whatever you've been telling yourself prior to sitting there in that chair today is wrong.
He tried to blame the wind for swerving all over the road. The judge is not having it. And honestly, when you hear the guy's actual drinking and driving history, you'll understand why. This isn't his first rodeo, or his second, or even his third.
Your hopes are not going to be met. You will be leaving through that door in about 4 minutes. You are not going to go to work and say, and give you another week. I don't know what the heck you've been doing in the last 2 months if you didn't tell them that was a possibility. That does not matter. You are 31 and you have 3 drinking and drivings within 6 years. And in this instance, you were all over the road enough that people called police. You were driving when you could not drive a car. You were unlawful for you to drive a car. And it was unlawful for you to possess a firearm. Was that, am I right?
Loaded firearm, yeah.
Yeah. No. I'm not going to let you go hunting. You can't possess a firearm. You can't possess a loaded firearm. And you were drunk with the blood alcohol level that would put most people in bed for a couple days, passed out. Oh no. I really hope what you told me was the truth. And if your mom's out there watching and she thinks to herself and she goes, well, I kind of let them have it, borrow it. It's her fault then that you got it. If she didn't, then that's not her fault. It's only your fault. I don't want to be insulting to your mother, but I'll tell you, if somebody else was letting you drive their car, they were wrong. Had you killed somebody, it would have been on them too. Yeah, no. And I appreciate you've been going to AA. That's great because you need it. Now I'm also looking here, and there's some issues here about, depression and anxiety. I don't see any medications or treatment because apparently you are treating everything with alcoholism. And you began using at a young age, age 17, 3 to 4 times a week in the last 13, 14 years. Wow. You set yourself up for failure.
Yes, Your Honor.
So, and I'll tell you why I talked about credibility. And that's what I jumped on right away when you started telling me about what you remember and then telling me I didn't do a good enough job explaining it to you. Well, you had 3/4 and there were 3/4 empty bottle of Smirnoff in the car. But actually, there were 2 bottles. You lied to the cops about what you had been drinking. Failed 3 tests that were given to you. So again, 31 years of age, and your criminal history began about 15 years ago. Unlawful driving away of a motor vehicle and malicious damage of property. You were given a chance. Then you have this fail to stop at an auto accident. Then you have in 2019 an open intox in a vehicle and violence charge, although there's only an open intox for a conviction. Then in 2020, sure enough, open intox and drinking and driving. 2022, open intox and drinking and driving. And then 2023, driving a vehicle while your license was suspended, denied, or revoked. I'm not going to ask, and I don't want you to answer because it ain't going to go well. Boy, I would like to know whose car that was. And then in 2023, which was while you were on probation for the last one, you picked up another driving license suspended, which means deception. You're going to do whatever you want when you think, and no one is looking. And then 2024, oh my gosh, failed to report an accident and driving license is suspended, denied, or revoked. Now that charge was dismissed, but if you fail to report an accident, it doesn't take much. It's a logical conclusion that you were driving while your license was suspended. And I would love to know whose vehicle you were driving those times. Who's ever allowing you to drive their vehicles? It's too bad on them. And now here you are in about a year, and you've got felony firearm, R&O, which I know those were dismissed, the possession while drunk, operating while your license is suspended and not revoked, which I know that was dismissed, but I can tell if you were drinking and driving, you were driving while your license was suspended. So I've got deception, alcohol, and violence wrapped all under one here. So, yeah, you might be a good employee, but boy, I would never let you walk into my place of business or work without giving you a breath test every single time. So I appreciate that you're getting the help here, and that's great. And I'm going to help. So at the age of 31, you realize your days of consuming alcohol are without a doubt gone. Because if you do it again and you get caught, your only next place to go is prison. And I would have no problem sending a 4th drinking and driver to prison.
Yes, Your Honor.
The court sentences the defendant as follows: 36 months of probation. You have the right to be considered for early release from that probation at halftime if you are successful with the terms and conditions of that probation. The court adopts every single one of the terms and conditions that are listed in CFJ 145, pages 2 and 3. I find that they're well suited for rehabilitative purposes. In this particular file, the court sentences the defendant to 12 months in the Missaukee County Jail, and he receives 3 days of credit. Court assesses a $68 state minimum fee for the felony, and there were 2, and the other is a $50 state minimum fee for the misdemeanor, $130 crime victims right fund fee, a $300 court cost, a $500 fine, and a $300 attorney fee for all the processing of this case from beginning to end. DNA fee was already available, apparently. Supervision fees are $30 a month or $60 a month if there's any electronic monitoring.
36 months probation, 12 months in county jail, and the judge makes it clear one more slip up and prison is next. If you want to see how judges handle repeat offenders like this, follow along, because this case is a masterclass in accountability.
So again, that's actually listed as 365 days. Okay. All right. Have I missed anything, Mr. Blazak?
I just wasn't sure if you were done with the second.
Oh, second, thank you. 93. I'm just going to go 90 days in jail with 33 days of credit. Those two sentences run concurrently with one another. All right. Thank you. Anything else, Mr. Blazak?
No, thank you.
Mr. Denham?
Nothing further on.
Okay. Mr. Hartel is going to bring you 2 copies of one document. You're going to place your initials on one copy. Doing so neither elects nor waives any rights. Based upon the plea, any appeal done in this case will be by filing an application for leave to appeal and not an automatic claim of appeal by right. Furthermore, If you wish to have the court appoint an attorney to assist you in an appeal, you may complete the bottom half of that document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. The number one thing you did wrong, the number one thing you tried to do today was try to tell me, oh yeah, now I remember, and I wasn't told well enough what was going on. I didn't understand. I don't believe you. Don't talk. You're going to make it worse. Just put your initial on that one page. The sentence is well within the guidelines. This is a straddle cell. The court could easily send the defendant to prison. And you're going to note one thing. Had I sent you to prison, you could have gotten boot camp. You probably could be out a lot faster than you will be when you're going that way. Thank you, Mr. Hartel. Keep blaming it on the wind.
My client has asked me to ask the court. I know the court.
Go.
Okay.
Go to jail.
All right.
It's not on weekends. You're going to jail. Blaming it on the wind, that was a bad choice. Thank you.